You believe your doctor was careless and caused you significant harm and injury. You know that the doctor at some point is going to come to you and actually admit that he was careless, and then take out his checkbook and then voluntarily write you a check for all of the money, for all of the harms and losses and damages that you incurred as a result of his carelessness. You think that's going to happen? You think the doctor is going to voluntarily write you a check right then and there once he recognizes that something was done wrong? Come join me for a walk around the lake as I share with you the reality of what's really going to happen. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Don't think for a second, no matter how badly you were injured, no matter how much you believe that your doctor was careless and caused you significant harm, is the doctor going to take out his checkbook and cut you a check to compensate you for all of the harms and losses and damages that you incurred because of his wrongdoing? It's not going to happen. I've been doing this now more than 36 years, and I will tell you in my entire career that has never, ever happened. And that is true regardless of how badly you believe you were injured and regardless of what you believe the doctor did to cause you all of these injuries. Now you may be saying, I don't understand. Doesn't the doctor acknowledge that he did something wrong? The doctor may in his own mind at some point question whether the treatment he rendered to you was appropriate. And ultimately, he's going to come to the conclusion that of course he did everything right. He's going to come to his own conclusion in his own mind and replay everything that he did for you and reach the exact same conclusion, which is that he did everything appropriate and that nothing he did caused you harm and injury. And that even if you did suffer harm and injury as a result of something that he did, he doesn't think that your injuries really are as bad as you claim them to be. And by the way, each one of those things that I've just told you about, those are called affirmative defenses. So ultimately, if you do bring a lawsuit against this careless doctor, once you have confirmation by a medical expert that the doctor was careless and caused you harm and injury, now, once you start the lawsuit, the doctor's attorney will go ahead and answer those allegations, pretty much denying all of them, and then saying, hey, wait a second, we did nothing wrong. You caused your own injuries, Mr. Patient. That's an affirmative defense where he's saying, look, I didn't cause your injuries, you did. You took various actions that caused and contributed to your own injuries, so don't point the finger at me. Then he's going to try and deflect and say, okay, if I did something wrong, well, guess what? Whatever I did not cause your injury. That's a causation defense, meaning that even if he admits that he did something that was careless, that he violated the basic standards of medical care, he's not saying that that caused your injury. He's saying that there's something else that caused and contributed to your injuries. That's also known as an affirmative defense. Then he's going to turn around and say, okay, if I did something wrong and whatever I did caused you harm, your injuries are not as bad as you believe them to be. That's also an affirmative defense, trying to limit and minimize the extent of your injuries. So don't think for a second that the doctor is, number one, going to acknowledge that he did anything wrong. And number two, don't think for a second he's going to acknowledge that whatever he did caused your injuries, because remember, there has to be a link, connection between the carelessness, the wrongdoing, and your injury. And then he's going to downplay everything you suffered as a result of whatever occurred to you and say, listen, your injuries are not as bad as you claim them to be. Don't think for a second that the doctor is going to pull out his checkbook and write you a check for the value of your injuries that you believe your injuries are worth. It's not going to happen. So instead, what does have to happen? If the doctor does not voluntarily acknowledge and recognize that his care and treatment of you was careless and violated the basic standards of medical care, causing you injury, well, guess what? The only way in this society today for you to obtain compensation for all of your disabilities and your inability to work, the only way is to go forward and see if you have a valid lawsuit. And the only way in New York to do that is to go ahead and obtain all of your medical records, to do a detailed, thorough investigation, and then we have to get confirmation by a medical expert who has reviewed all of those records. Only if a medical expert determines, yes, your doctor violated the basic standards of medical care, and as a result of that violation or carelessness, you suffered significant harm and injury. Now, because we have confirmation and support with a medical expert, only then are we permitted to go forward and start a lawsuit on your behalf. Now, even if we do all that, does that guarantee that you're going to get money as a form of compensation for your injuries? The answer is no, because in these types of civil lawsuits, there are no guarantees, no matter how many experts we have, no matter how much we believe that the doctor was careless, no matter how much you believe in your heart of hearts that your injuries arose from this doctor's treatment of you and his carelessness, and you falling through the cracks or having him do something that he should not have done, or failing to do something he should have done. No matter how much that occurs, there is no way to guarantee that ultimately they will recognize that they need to settle this case. And even if they don't, there is no way to guarantee that when we go to trial, that a jury, 6 members of the community, are going to agree with us on each and every one of the claims we are making. Now, let me jump ahead for a second. Let's say the defense refuses to acknowledge they did anything wrong, and they refuse to acknowledge whatever they did caused you harm and injury, and they refuse to recognize the true value of your injuries. Now your case proceeds through the litigation process, and now we get closer and closer to trial. The defense tells us, hey, listen, we're not going to negotiate. We don't believe we did anything wrong, and we're not going to offer a dime. What does that mean? It means you're going to trial. It means 6 members of the community, people whom you do not know, are now going to be sitting in judgment to decide whether we are slightly more likely right than wrong than what we are claiming is true. The jury will have to decide, number one, whether your doctor, the doctor whom you have sued, was careless. That will be one of the very first things they have to decide. If the answer is no, your case is over and you walk away with nothing. If the jury, however, determines, yes, your doctor was careless, the next question they have to answer is whether the doctor's carelessness was a cause of your injury. We call that proximate cause. If the jury determines, yes, your doctor was careless, but there was no connection between the carelessness and your injury, guess what? Your case is over and you wind up with nothing. If, however, the jury does come back and say, yes, the doctor was careless, and yes, his carelessness caused you harm and injury, now the jury has to go through and evaluate the extent of your damages. They have to determine how much your injuries are worth. Your past pain and suffering, your future pain and suffering for the remainder of your life, for actual economic losses that you incurred as a result of the doctor's carelessness, for your lost earnings, assuming you are no longer able to work. The jury will then have to go through line item by line item to determine what they believe you are entitled to receive. Now, does that mean that you are going to get the $1 million, the $10 million, the $25 million that you believe your case is really worth? The answer is, that's unknown. And it's unknown because we won't know and we don't know what's going through the minds of the jury after having sat through an entire trial that could have gone on for weeks. We are not permitted to get a window into what the jury is thinking and what they are deliberating upon and what issues they have come upon. We are only allowed to see the result of their deliberations. And that comes in the form of a jury verdict. And at the end of all that deliberation, the jury will then come out of the jury deliberation room and announce to the court their final results in the form of a jury verdict. And the verdict really is the answers to those specific questions that the judge has tasked them with answering. It is only if the jury determines, yes, your doctor was careless, yes, his carelessness caused you harm, and yes, your injuries are significant and or permanent, and now they have to allocate a particular number to each of the damages that you are claiming in this particular case. So why do I share this quick information with you? I share it with you because there are some injured patients who believe in their heart of hearts that the doctor should immediately get out their checkbook, they should immediately acknowledge that they did something wrong, and that should be the end of it. There should be no need for any litigation. And in an ideal world, that would be wonderful. But does that really happen? The answer is no, it doesn't. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.